I am the last speaker of the day, and I'm sure you can imagine that my day has been much longer than yours. However, it was very interesting. The presentations were very interesting, and as colleagues before me, of course, I wish to thank to the Central European Academy for inviting me to this indeed very special conference, and I'm really grateful to have this opportunity. As you can see on the screen, I will be talking about the status of the international and supranational rule of law in the Slovenian legal system, and addressing this main theme. I will also try to explore briefly the lessons on the rule of law that were given to Slovenia by European courts, particularly or exclusively by the Strasbourg and Luxembourg court, of course. Obviously, I have to begin somewhere, and and I will do it by introducing some general remarks on the rule of law. I will not define rule of law, but at the very beginning, I would just like to stress that as a legal concept and a fundamental legal principle, the rule of law is almost universally accepted. It is accepted at the national and international level. It is accepted in both the formal, that is institutional, and informal, theoretical and political discourse. It is accepted by liberals and conservatives, by the left and the right. Interestingly, Chesterman maintained, and I think with a bit of irony, that it is a term endorsed by both the World Social Forum and the World Bank. And he further argues that widespread support for the concept is actually possible precisely because of widely divergent views of what it means conceptually and practically. In my view, this coin of widespread support also has the flip side, as every coin does, namely within the legal academia in the late 70s, for example. The concept was subjected to criticism by the left, like Marxists, feminists, postmodernists, etc., and also, although to a lesser extent, by the right, for example, by the proponents of the school of thought which is known as law and economics. But leaving aside this ideological battle surrounding the concept of the rule of law, historically there are three basic versions of the concept evolved. Of course, the constitutional concept, it developed domestically, keeping the nation state sovereign, and also the international concept and the supranational concept. These two concepts developed in the post-war period, of course, and they introduced certain limitations to national sovereignty. I studied the status of the international and supranational law and the rule of law within the Slovenian legal system, and in my presentation I will show that on the one side, in relation to the international law and the rule of law, the Slovenian internal law preserves constitutional sovereignty, but not as straightforward as it may seem. And on the other side, a different constitutional regime applies to the EU law and the supranational rule of law. What makes life difficult here is that its status is not entirely clear in the Slovenian constitutional system. Actually, in the Constitution, there are several provisions that determine the position of both corpuses of law vis-à-vis internal law. And of course, at least at the normative level, these provisions incorporate the international and supranational rule of law into the legal system of the Republic of Slovenia. Regarding the status of the international law and international rule of law within the Slovenian legal system, Article 8 is important. According to this article, principles of international law and international treaties ratified by the National Assembly are superior to the statutory laws, government regulations, and any other general legal acts, but inferior to the Constitution. And here we see that Slovenian internal legal order, indeed, in relation to the international law, preserves constitutional sovereignty. If inconsistent with the Constitution, international treaties cannot be implemented, as this would be unconstitutional. Actually, they would be without legal effects, but here I have to draw your attention to the fact that in practice the thing is not that simple. Slovenia could, for example, commit to something in an international treaty that would be in conflict with the constitution, and this would, of course, raise this issue of pacta sunt servanda. And in order to avoid such situation, Slovenian constitution envisages this Article 160, according to which, in the process of ratifying an international treaty on the proposal of the President of the Republic or the government or a third of the deputies of the National Assembly, the Constitutional Court shall issue an opinion on the conformity of such treaty with the Constitution, and National Assembly is bound by such an opinion. Here we see that in Slovenia we obviously have introduced this preventive review of constitutionality when it comes to international treaties, of course, but the problem still could arise if an international treaty would already be ratified and valid, and then post festum there would be some doubts raised that whether it is in conformity with constitution or not. But maybe even more important thing to be pointed to here is Article 15, which introduces so-called non-enumeration clause, meaning that it envisages a special situation in which international law would take precedence over the constitution in Slovenia. And according to this clause, if an international treaty provides a higher standard of protection of human rights and the rule of law than the Slovenian constitution, priority should be conferred to the international treaty. Obviously, this non-enumeration clause opens the constitution's human rights catalog also to the human rights that are stipulated in the international treaties, and this is a kind of exception to this constitutional sovereignty which I was talking about at the beginning. When it comes to the status of the supranational law and the rule of law in the Slovenian legal system, Article 3 is important. This article was actually added to the constitution in 2003, just before Slovenia became a member of the European Union. And this article provides a constitutional basis for the transfer of the exercise of part of sovereign rights to international organizations which are based on respect for human rights, democracy, and the principle of rule of law. This is actually the exact wording from the Article 3 of the Constitution, and interestingly, it does not explicitly refer to the European Union. But it's obviously, and at that time when it was created, it was aimed for the Slovenia's accession to the European Union. What is important with regard to this article is that in one of its provisions, it stipulates that legal acts and decisions adopted by the European institutions shall be applied in Slovenia in accordance with the EU law. So this provision misses, as you can see, an explicit and precise determination of the hierarchical position of the EU law in relation to domestic law in Slovenia, and this caused considerable discomfort in the Slovenian legal system. And in theory and practice, two different views emerged regarding this position, the position of the EU law. The first approach was this supranationalist approach, and I think this is prevailing approach still in Slovenia. In line with this approach, Slovenia recognized the principle of supremacy of primary source of EU law, meaning that legal rules in the EU treaties should prevail and have supremacy over the legal and constitutional rules of the internal law, and no ground to refuse the use of such provisions of primary EU legislations and individual legal acts based on it, if found contrary to the Slovenian constitution, should be referred to. All in all, sovereignty, in line with this approach, sovereignty has been transferred, at least partly, within the limits of the competencies of the EU to the European Union. But over time, some EU law experts started to argue that this supranationalist approach to viewing the relationship between the two corpuses of law is not convincing, neither theoretically nor practically. And they proposed this alternative pluralist approach. In line with it, the leading principle underlying the relationship between the two corpuses of law is a relational principle of primacy. And according according to this approach, relationship between the two corpuses of law is heterarchical, not hierarchical, meaning that national law is not subordinated to the EU law, and the decisions of the EU institutions, including courts, and also the decisions of the EU institutions, including courts. In other words, effectiveness of the EU law and decisions of the EU institutions in the territory of the Republic of Slovenia is not unconditional, meaning that this territory consists of two independent yet interrelated legal systems. Aubel is the name of my colleague, constitutional lawyer, who is also an expert in European Union law. He claims that here we have some kind of plural sovereignty. Slovenia remains sovereign in the usual sense, while the EU has acquired functional sovereignty within the framework of transferred competencies. And according to Aubel, this doctrine was built for several decades, and it was proved by the German Constitutional Court in the famous Weiss case. And according to German Federal Constitutional Court, or the German Federal Constitutional Court held in this case that Court of Justice of the European Union judgment was arbitrary and not binding in Germany in this particular case. And similar decisions were also taken by some other courts, as was earlier today mentioned by David. What is most important here is that in case of a serious conflict between the EU law and decisions and the Slovenian national law, the principle of primacy of EU law should apply only if the EU respects the principle of democracy, the rule of law, and human rights, and if it operates within the boundaries of transferred powers. If this is not the case, the Constitutional Court could exceptionally decide that the EU law should not be applied. But this is a theory. The reality is such that so far in Slovenia, highest courts, including Constitutional Court, have not taken a challenging stance toward EU laws decisions once they were taken. And this Aubel's expert opinion has not been accepted by the courts in Slovenia. Now speaking, and this will be the final part of my presentation, speaking of lessons from the European Court to speaking about lessons of European courts to Slovenia regarding rule of law. First, I will address lessons, and I put lessons in quotes, as you can see, from the European Court of Human Rights. I reviewed randomly selected case law, and I found that in the vast majority of judgments, the court does not explicitly refer to the principle of rule of law. Even I also reviewed 29 so-called so defined noteworthy cases that concern Slovenia according to the court's press unit, and I only find direct references in two cases. However, I have to clearly point out here that in some, or even in majority of reviewed judgments, of course, the court refers to the principles and elements that are constitutive of the principle of the rule of law or are inextricably linked to it. Also, I would like to stress here that European Court of Human Rights stated in several decisions that the rule of law is inherent in all the articles of the convention, meaning that if there would be a violation established by the court, a violation of the human rights, the convention rights, this would also mean, of course, the violation of the rule of law. But nevertheless, among all these cases I reviewed, there were three seminal cases in which court interpreted the principles of the rule of law differently from the Slovenian authorities, and in Benedict case also differently from the Constitutional Court. But what I found out is that European Court of Human Rights established more strict standards of the principle than those provided by the Slovenian judicial and other authorities. And I think this should be understood in the context of the fact that Slovenia has been consistently enforcing the judgments of the European Court of Human Rights, and also that in the public and professional discourse, the court's understanding of the rule of law has not been seriously challenged at all. And last but not least, also Slovenia did not appeal any of the judgments at the Grand Chamber of the European Court of Human Rights. And from this, we can conclude that Slovenia recognizes the European Court of Human Rights full sovereignty, of course, within the scope of its powers. Regarding lessons from the Court of Justice of the European Union, I reviewed 4 randomly selected preliminary ruling cases. Interestingly, in none of these cases I found direct references to the rule of law. But I did find references to the rule of law in the Commission versus Slovenia case dated December 2020. Actually, in this case, in this decision, in this judgment, the rule of law was one of the key concepts referred to by the Court of Justice of the European Union. This case related to the fallout of the financial crisis in 2018, when Slovenia saved private banks with taxpayers' money, and due to allegedly too high costs of these banks' bail-ins, questions of responsibility of the governor and certain employees of the Bank of Slovenia arose. Slovenian police carried out house search in the Bank of Slovenia and seized some national documents as evidence, but what is important here is that these national documents also contained some information which was provided by the European Central Bank. And the Bank of Slovenia claimed that the investigation interfered with the European Central Bank's archives, protected by the Protocol on Privileges and Immunities, to which the Slovenian authorities were not to have access without an explicit agreement of the European Central Bank. And as a result, Court of Justice of the European Union found that Slovenia has failed to fulfill its obligations under the treaties and protocols. Aubel, the aforementioned EU law expert in Slovenia, assessed this judgment as clearly wrong, and I think that he did rightfully so. Namely, according to him, of course, immunities and privileges are common in the international law, but exceptional in a constitutional system based on the rule of law. And as we have heard earlier today, European Union is based on the rule of law. And according to Aubel, Slovenia correctly warned that the Court of Justice of the European Union's interpretation goes beyond what is stipulated in the international law, with opposing the trend of narrowing the functional immunity of international organizations. To summarize and to conclude, while in relation to the international law, the Slovenian internal law preserves constitutional sovereignty. A different constitutional regime applies to the EU law, but in the absence of an explicit constitutional rule on the hierarchical position of the EU law in the relation to domestic law, 2 different views emerged in Slovenia, and at least in theory, the supranationalist approach was replaced with a pluralist approach. While scrutinizing, while reviewing the jurisprudence of both courts, I found that the domestic interpretation and understanding of the rule of law differed from the international and supranational one. However, an important difference between the judgments of both courts was noticed. Namely, European Court of Human Rights interpreted the rule of law in such a way that it established more strict standards of this principle than those provided by the Slovenian judicial and other authorities, and neither by the authorities nor by legal experts its decisions have been seriously disputed. In contrast, in at least one of the reviewed judgments, but there are more, the Court of Justice of the European Union interpreted the rule of law in such a way that it was not only incompatible with the interpretation and understanding by domestic courts, but also with the established international standards of the rule of law. However, once the judgment was issued, Slovenian courts or other authorities did not challenge it in any way. So with regard to this later point, I would just like to add one final remarks. I think that in the future, the Slovenian Constitutional Court, as the final defender of Slovenian constitutionality, not to say constitutional identity, should strive to follow more courageous national constitutional courts of which David was talking earlier today, and when necessary, take a position of critical restraint in relation to the EU law and the decisions of the EU institutions. Thank you very much.